Everything I share today is for educational purposes only. This is not legal advice, and I am not your attorney. If you or someone you love is being held in solitary confinement and you believe their constitutional rights are being violated, contact a licensed civil rights or criminal defense attorney immediately. 23 hours a day, alone, in a cell the size of a parking space. No human contact, no natural light, no programming, no rehabilitation. Just four walls, a metal bed, and silence that drives people to the edge of sanity. This is not a scene from a dystopian novel. This is happening right now in prisons across the United States to thousands of people. Some of them have been in solitary confinement not for days or weeks, but for years, decades. One man in Louisiana spent 41 years in solitary confinement, the longest known case in American history. The question I am answering today is not whether this is humane. The question is it legal? What does the Constitution say about it? And what rights do prisoners have when the state decides to lock them away from all human contact indefinitely? The issue: solitary confinement, formerly called restrictive housing or administrative segregation in prison policy language, is the practice of isolating a prisoner in a single cell for 22 to 24 hours per day with minimal or no human contact. It is used in American prisons for various stated reasons, including punishment for rule violations, protection of vulnerable inmates, management of gang-affiliated prisoners, and housing of death row inmates. The legal question is whether this practice, particularly when extended over months or years, constitutes cruel and unusual punishment under the Eighth Amendment, and what legal remedies exist for prisoners whose mental and physical health is destroyed by prolonged isolation. The law. The Eighth Amendment to the United States Constitution prohibits cruel and unusual punishment. This is the primary constitutional provision governing conditions of confinement in American prisons. The Supreme Court addressed solitary confinement directly in the 1890 case in Re Medley, ruling that prolonged solitary confinement caused such serious psychological harm that it could constitute cruel and unusual punishment. That was 1890, over 130 years ago, and the practice continues today on a massive scale. The modern legal standard for Eighth Amendment conditions of confinement claims comes from two key cases. In Wilson v. Saiter in 1991, the Supreme Court ruled that to succeed on a conditions of confinement claim, a prisoner must prove two things. First, the deprivation must be objectively serious enough to constitute a denial of the minimal civilized measure of life's necessities. Second, prison officials must have acted with deliberate indifference to that serious condition. Simply showing that conditions are harsh is not enough. The prisoner must show officials knew about the serious harm and consciously disregarded it. In Helling v. McKinney in 1993, the court confirmed that the Eighth Amendment protects prisoners not just from current harm, but from conditions that pose an unreasonable risk of serious damage to future health. This ruling has direct application to solitary confinement cases because the psychological damage of prolonged isolation frequently emerges over time rather than immediately. What science tells us is unambiguous. The American Psychological Association, the United Nations, and virtually every major medical organization in the world has concluded that prolonged solitary confinement causes severe and lasting psychological harm. Anxiety, depression, hallucinations, paranoia, self-harm, suicide. These are not theoretical risks. They are documented, consistent outcomes of long-term isolation. The United Nations Standard Minimum Rules for the Treatment of Prisoners, known as the Nelson Mandela Rules, define prolonged solitary confinement as any period exceeding 15 consecutive days and classify it as cruel, inhuman, or degrading treatment that may amount to torture. The United States has not formally adopted these rules domestically, and American courts have been inconsistent in applying Eighth Amendment protections to solitary confinement cases, with some courts finding violations and others deferring heavily to prison administrators on security grounds. Real-world application. Albert Woodfox was arrested in Louisiana in 1971 and placed in solitary confinement at Angola Prison following a prison murder conviction. A conviction that was overturned 3 times by federal courts citing constitutional violations before he was finally released in 2016. He spent 41 years in a 6 by 9 foot cell, 23 hours a day, alone. When he was finally released at age 68, neurologists and psychologists who examined him documented extraordinary resilience, but also lasting damage. He had maintained his sanity through disciplined mental practice and political study. Most people subjected to a fraction of that isolation do not emerge intact. His case became a landmark in the ongoing legal and political battle over solitary confinement in America, and it illustrates the core legal problem. Courts overturned his conviction 3 times over 41 years, yet he remained in solitary throughout, because prison administrators retained the authority to keep him there on security grounds, regardless of what the court said about his underlying conviction. Common mistakes. The first mistake families make is assuming that prison officials have unlimited authority over conditions of confinement. They do not. The Eighth Amendment applies inside prison walls. Prisoners retain constitutional rights. Those rights are limited, but they exist. And conditions that constitute cruel and unusual punishment are legally challengeable, regardless of what prison policy says. The second mistake is not exhausting administrative remedies before filing suit. Federal law under the Prison Litigation Reform Act of 1996 requires that prisoners exhaust all available administrative grievance procedures before bringing a federal lawsuit over prison conditions. Failing to file grievances through the prison's internal system, even when those grievances are routinely denied, can permanently bar a federal lawsuit. Every grievance must be filed, documented, and appealed through every available internal step before going to federal court. The third mistake is waiting too long to document psychological harm. Medical and psychological records created during the period of solitary confinement are critical evidence in any legal challenge. Families should request that incarcerated loved ones request mental health evaluations, report symptoms in writing to prison medical staff, and document every instance of psychological distress through the prison's own record system. This contemporaneous documentation is far more powerful than retrospective testimony about harm suffered. The fourth mistake is not knowing that juvenile solitary confinement has additional constitutional protections. Following the Supreme Court's decisions in Roper, Graham, and Miller recognizing the developmental differences of juveniles, federal courts have shown increased willingness to find Eighth Amendment violations when juveniles are placed in prolonged solitary confinement. Families of incarcerated juveniles should specifically research the enhanced protections available in their jurisdiction. The fifth mistake is not contacting civil rights organizations that specifically litigate solitary confinement cases. The ACLU National Prison Project, the Center for Constitutional Rights, and state-specific prisoners' rights organizations have brought successful class action litigation challenging solitary confinement practices in multiple states. Individual cases are difficult and expensive. Class action litigation targeting systemic practices has produced real reform, including consent decrees limiting solitary confinement use in several state prison systems. Your action steps. 1. If a loved one is placed in solitary confinement, immediately begin documenting everything. The date placement began, the stated reason, every request for review that is made, every mental health symptom reported, every medical visit. Build a written record from day 1. 2. File internal grievances through every available step of the prison's grievance system, even when you expect them to be denied. Under the Prison Litigation Reform Act, this exhaustion is legally required before any federal lawsuit can be filed. Do not skip this step, no matter how futile it feels. 3. Request a mental health evaluation through the prison's medical system as soon as possible and at regular intervals. These official records of psychological deterioration become the evidentiary foundation of any constitutional challenge. 4. Contact a civil rights attorney who handles prisoners' rights cases. Explain the duration of solitary confinement, the reason given, the medical impact, and the grievances filed. An attorney can evaluate whether the specific circumstances meet the constitutional threshold for an Eighth Amendment claim. 5. Contact organizations, including the ACLU National Prison Project and the Center for Constitutional Rights, to report the situation. Even where individual litigation is not feasible, documented reports contribute to the systemic evidence base used in broader class action challenges that have produced legislative and policy reform. The Eighth Amendment drew a line. Punishment in America cannot be cruel and unusual. The science is clear. The United Nations is clear. The medical community is clear. Prolonged isolation destroys human beings. The law has been slow to catch up, but it is moving. Courts are increasingly willing to examine what happens inside solitary confinement cells. Legislation has passed in several states limiting its use. The legal tools exist. Know them, use them, and share this with someone whose loved one is sitting alone in a cell right now, with no idea that the Constitution still applies to them. For any real legal situation, always speak with a licensed civil rights attorney immediately.